You're watching 13 WMAZ Law Call, sponsored by Macon Law Firm, Reynolds, Horn, and Servant. Your rights, your calls, live. This is 13 WMAZ Law Call.
Well, hello and welcome to Law Call. I'm Morgan Dukes, and tonight I have two great attorneys from Reynolds, Horn, and Servant with me, and they're going to answer your questions. So help me welcome Mr. Carl Reynolds. How are you, sir?
I'm great, Morgan. How are you doing tonight?
I'm doing really good, really good. You know, we have such an important topic that we're going to talk about because everybody deals with products. A lot of people have experienced a slip and fall. Some folks have experienced an accident of some kind. And that's one thing that your particular firm certainly deals with. So we have a lot to get to tonight.
Well, we've had a lot of experience with product cases. With us tonight is BJ Servant. He has certainly been the lead on a number of cases in our office. We went through a series of a lot of rollover cases where the roof collapsed on SUVs. BJ, you could talk about that, as well as a number of other products I think we've handled.
Yeah, we've done generally the SUV rollover cases you mentioned. We've done a deer stand case. We looked at a couple. We took one all the way to the eve of trial before we got that one resolved. We've done the wheel cases. Yeah, we've done a number of product cases.
Yeah,
Okay.
for years we did multi-piece rim cases where truck rims would come apart and injure people badly. In fact, just today, we were a little late getting here because we were videoing a pressure cooker that exploded and burned our client all over his chest and stomach and had to be taken to the burn center in Augusta and have cadaver skin put on there until he recovered. But it was a very serious case. And frankly, I'm scared of pressure cookers, but my wife uses them. This man had one. He'd used it for a year, and he had cooked, and the little button went down to show there was no pressure, and he went to open the lid, and it exploded all over him.
Oh, wow.
So the thing is, and we've mentioned this in an earlier show, the legislature has always enacted laws that make it more difficult for everyday people to get into a courtroom. They do this by enacting statutes and passing legislation that just creates hurdles and impediments by raising the cost of getting to a courtroom and having a jury hear your case and render a judgment. This is as true in product liability as it is in medical malpractice. And I would even go so far as to say the enemy of the people is in many cases, is the legislator acting at the behest of lobbyists in terms of medical malpractice and product liability. It has been that way for the last 25 or 30 years. BJ, would you care to comment on that?
Well, one example of what you're talking about is in Georgia, punitive damages are a big thing in product cases because that's what could deter or make the manufacturer of a defective product change how they design and how they manufacture the product to turn a dangerous product into a safe product, like the SUV cases. All they had to do was widen the wheelbase by about 1/4 of an inch, and it wouldn't have flipped over, but they refused to do that until they got hit with verdict after verdict after verdict, and all of those including punitive damages. Well, Georgia steps in and they decide that in punitive damage cases only, not in any other kind of cases, but in punitive damage cases, product cases only, the punitive damage award, you can have them, but only one bite. In other words, one plaintiff gets punitive damages, and then 75% of those damages go to the state of Georgia. They don't even go to the plaintiff.
Wow.
So it's another reason to make a product liability less attractive to a plaintiff's attorney because the damages aren't there. And it kind of impedes the purpose of punitive damages, that is to change the conduct of the manufacturer, because they only get hit one time and they got a lot of money.
Where he's going with this too is talk about the one bite at the apple. On the case we're sending off to an expert today, the pressure cooker. we deal a lot of times with what we call OSIs, other similar incidents. And on this particular product, it turns out that there have been numerous cases where people have been badly burned by this product. So that puts them on notice that there's something wrong. They should recall it. They should do something to notify the public. But if there's been a verdict against them in which punitive damages were rendered, that ends that. Is that what I understand, BJ, that you're saying?
In Georgia, it would, yes.
In Georgia, yeah, I'm talking about Georgia. And just so that the viewing audience understands it, the three types of damages: direct expenses or special damages. General damages are for pain and suffering or for the value of a life to a decedent. Those are general damages. And then punitive damages are those damages that may be awarded to deter future like conduct on the part of the defendant, to deter future like conduct. And I can tell you that a strong plaintiff's verdict for a product that is inherently bad and dangerous will do more to change and shape the conscience of the manufacturers than any legislation ever passed. So we're pretty passionate about product liability.
Oh, I see. And with good reason. That's important. Now, I have a question. Actually, it's from one of our email questions. It's from Cassie, but it has to do with all of these commercials that we hear. You know, when you think about the commercials and those long disclaimers at the end of every single one of them, does this actually clear the product from any lawsuits? That's what Cassie wants to know, and that's what all of us want to know.
Well, my short answer is no. I'll let BJ deal with that.
That's what I was going to give you. No, it doesn't, Sheila and Morgan. What they're doing is, there's a number of ways to deal with putting a product out in the stream of commerce to make sure it's safe. One, and the basic one, is to design a safe product. The second way is, the second thing is to make sure when you design the safe product that you manufacture it safely. You use good parts. You put everything together like you're supposed to. You have inspections so that it's properly manufactured. And then the third aspect is you need to properly warn users of any problems they might should look for. So if there's a danger in that you can't design out, you can't manufacture it out, then you need to warn the people about it. And you need to be very specific about what those warnings are. And there's a whole field of expertise in litigation and in science called human factors. And that's basically goes into what warnings are and whether they're something that would convey the damage or the danger specifically to the user. And there's a whole bunch of litigation about that. But all these rapidly talked disclaimers in connection with drug ads is just that, so they can say later down the line that, well, we warned them, but that doesn't really do much.
Well,
doesn't do much good.
To put it all in perspective, Morgan, and we've talked about this on the medical malpractice. This is in terms of cost of prosecuting a product liability case, it's like medical malpractice cost on steroids. We, on one of the multi-piece rim cases, it's actually an RH5 degree multi-piece rim manufactured by a number of manufacturers, notably Firestone, but several different manufacturers manufactured it. And this is a base with a ring on it that has a 1/32 inch of design interference. And it would blow up with enough force to lift a passenger automobile 25 feet off the ground or catapult a bowling ball about a half a mile. And when they go off near somebody, they're either decapitated, they're truncated, they're maimed, or they're killed. And the last one we tried, it was a substantial verdict. It was a $19.1 million verdict. A young man had 1/4 of his head taken away, and he was rendered a triplegic. And there were numerous other cases exactly like this. But in all of the prior cases, they had been settled by the manufacturers. And with the settlement came what is known as a confidentiality agreement, which means that all of the material in the Firestone files that told of how much they knew about the danger of the product were sealed. So we decided we would go all the way through a trial with it. The point of the story is this: from start to finish, it took 7 years. The actual out-of-pocket expense in the case was over $500,000. And that does not count the time of all of the people in our firm and on the staff who went back and forth to Ohio to go through their files to make copies. So
Wow.
you just, it's one of those cases where you just don't start it unless the potential damages are astronomical. And you
Wow.
don't get the potential for astronomical damages unless the injuries are truly catastrophic.
Okay. Well, I'll tell you what, we're going to take a quick break right now. We're going to come back and talk more about what happens when a product injures you or if you get injured in general. So we're going to discuss that next right here on Law Call.
You're watching Law Call on 13 WMAZ with personal injury attorney Carl Reynolds, who has recovered more than $500 million for his clients, dedicated to helping injured Georgians for more than 50 years, plus support from his Macon law firm of Reynolds, Horn, and Servant, including attorney Wendell Horn, focused on protecting the rights of car and truck wreck victims across the state, and attorney B.J. Servant, aggressively representing those injured by medical malpractice, hosted by award-winning broadcaster Morgan Dukes, featuring guests from across Middle Georgia. Your rights, your calls, live. This is Law Call on 13 WMAZ.
And we're back. We are back. You're watching Law Call. I'm Morgan Dukes, your host tonight. And with me from the law firm of Reynolds, Horn, and Servant is Mr. Carl Reynolds and Mr. B.J. Servant. Gentlemen, it's always good to be with you, especially when we can get some answers to the people who need it most. And we do have some email questions coming in. And I know that you're here to offer the good expertise that you offer. So let's get to Debbie's question. And her question has to do with what happens when you get hurt on the job. That's what happens to her husband. Her husband's hand was almost severed when the guard on a power saw he was using snapped off. He had some serious injuries to his hand, his wrist, and his forearm. And the manager of the store that he brought the saw from said that they needed to contact the manufacturer. Her question is, should she call you? Should she get a lawyer before she does that? What should a person do?
That's about a 3-part question, but taking them in reverse order. Yes, she should get a lawyer. That's true. If it was in Georgia, the owner of the retail establishment where they bought the saw probably is right. It would go back to the manufacturer and not the vendor. Is that correct, BJ?
Well, you could have some warranty claims, not defective product claims.
Yeah, have there been some changes in that? And if he was on the job, as to his employer, his total recovery would be within the realm of the workers' comp claim. Now, as to the product, that's a whole different story. I don't know what the specific malfunction was. Did you get that?
I said a guard failed on a power saw, so
yeah,
it was either it was inadequate or not put together appropriately, I would guess.
Yeah, and it could have been on a failure to warn. You mentioned that earlier, BJ, and I was going to raise a point about that. I think there was a statute passed not too long ago that in Georgia as to product defects, wasn't there like a 10-year statute of repose?
Yeah, there is. As to Georgia has a strict product liability statute, so you have to prove defective product and there's strict liability. That only lasts for 10 years from the date of manufacture.
But the escape clause is you can go to the failure to warn,
right?
Even if it's more than 10 years old.
Right. That's good to know. But you know what? You brought up a very good point with this last person's question that it had so many different segments, and it all begins with, yes, you should contact a lawyer. If you have a problem with anything, really, I mean, whether it's a slip and fall or workman's comp, it had, that element to the question, as well as a product liability possibility.
You're right, Morgan. But one point we should make too is that mostly on these kinds of cases, the product liability cases, and to a lesser extent on the medical malpractice cases, I would say the ones that we have actually taken and prosecuted all the way through a jury trial almost always come from lawyers who don't really do trial work. You hear a lot about, quote, personal injury lawyers. That is just an invasion of trial work by people who want to capitalize on simple negligence cases involving automobile wrecks. If you've got a case, go to whatever lawyer has represented you or your family over the years, and I can promise you, whether that lawyer does trial work or not, he will get you into the hands of somebody who does. And that's a very important point to remember. Don't go to somebody who you see on a billboard or yells from the top of a tractor trailer truck, me, come to see me. I think that's just bogus.
And Morgan, another consideration, you said go to a lawyer, and that's absolutely true. And in a product liability case, particularly because without the product, you don't have a product liability case. And if anything happens to the product and you lose possession of it, or something happens to it, you can't prove your case, and you have the burden of proving. So if you go to a lawyer, the lawyer's going to know that, and the lawyer's going to say, well, where's the saw? And he's going to secure the saw, and then he can hold it until there's a decision about whether, an engineer or some expert needs to come look at it and determine whether there's a defect. But the whole way through, you have to have the product.
And you know what? It's important to also mention that you all offer, Reynolds, Horn, and Savant offer free consultations. Am I correct?
Yeah, most everybody does that. I mean, any lawyer will talk to you. Again, if you go to one of these firms that again, shouts from the rooftops, come see us, they're going to probably find a law firm that will handle this kind of case. And BJ is absolutely right on any individual product. For instance, this morning, the pressure cooker. We have to have that pressure cooker. And it's so important that we had it wrapped before it was brought to us. We had our expert on the line. We had a Zoom conference. He instructed us on how to unwrap it, how to disassemble it, how to clean it, then how to repack it and ship it to him. Without the product, we wouldn't have a case, even though this man was horribly burned. Now, there is a rare exception, BJ, in other states, right. And this came up on a specific product, that is the RH5 degree split rim. We did try a case in, I believe it originated in California, and they had lost the rim. So we sued every manufacturer that manufactured that rim and asked for a proportionate amount of damages based on their market share in the market. But that was a very, very specific case and a rare exception to the general rule you're talking about.
Okay. Well, I'll tell you what, we're going to take a quick break and we're going to come back and find out what happens when a product injures our puppies, our animals, our pets. We're going to talk about all of that next. I'm Morgan Dukes, and this is LawCall. If you would like to contact Mr. Carl Reynolds or BJ Savant, you can reach them at Reynolds, Horn, and Savant right here in Macon. The telephone number is 478-405-0300. You can also check them out online at www.reynoldsinjurylaw.com. And don't forget to follow Reynolds, Horn, and Savant on the internet. You can find them on Facebook. I'm Morgan Dukes, and I am just delighted to have both of these attorneys tonight answering your questions about what do you do when you get hurt, whether it's by a product or perhaps some other means, but they are certainly available for free consultations. So don't hesitate to give them a call if you have further questions. Now, Chanel sent us a question that's kind of interesting, but we do have a whole lot of pet lovers and pet parents that watch the show. And her question pertains to her dog. Her question is, I use a flea and tick medication on my dog and it made her really sick. And since then, I've read that other people have had the same problem. How can I prove that the medication is dangerous and get the company to pay the medical bills? I think that's a fair question, but how does Chanel go about getting some results? BJ, aren't you? BJ, aren't you?
Look, I mean, when you get right down to it, unless that dog has a market value, you can't sue on behalf of an animal. I mean, I love dogs. I've got a bunch of dogs. We sued a case one time because a deer hunter shot a man's hog dog, and we actually got a verdict of $10,000. But that was the market value of the hog dog. As a pet, I mean, you're limited to what you can do in terms of the value of the dog. I mean, I guess you could, BJ, could you ask for punitive damages in that situation?
It would depend. I doubt it. I mean, you hit the nail on the head. It gets to the point where you've got a claim that there really isn't any upside in terms of damages, and proving you'd have to get us, experts involved to prove that it was a defect. It would just be a big hassle, and without anything at the end of the tunnel to make it worth your effort.
Well, again, I mean, you could go through things like the Better Business Bureau. You can file complaints. You can threaten publicity about the product. But as far as having an ultimate decider of fact in a situation like that, in the way of a jury, no, you've got nowhere to go, and I'm sorry.
Really? See, and I'm thinking, your dogs, the expenses for an animal to be a pet parent can be quite costly when it comes to veterinarian deals, because they have surgery and all of these other factors. And if they get the wrong medication, they could die. So what about, emotional damages, or even if it's an emotional support dog? How about that? A support dog?
None.
Would that matter?
None. No, it doesn't matter.
No.
Doesn't matter.
Sorry, it just doesn't matter. I mean, I had a lady call the other day. Her bulldog had gone into the vet. They literally malpracticed the dog or the lady, and the dog died, and she was devastated emotionally. But there is no value to that bulldog as a pet. And certainly the toll on her was devastating and almost imponderable. I mean, she suffered much over it, but there's no cause of action there that she could maintain.
Yeah, as a matter of fact, there was a big name lawyer up in Atlanta who had a dog that died, similar situation, and he knew the law and what it was, and he knew he didn't have a case, but he was trying to change the law, trying to present a case that his dog was special and the dog had this intrinsic worth and they needed award damages, blah, blah, blah. And he took it all the way to state Supreme Court, and they agreed with Carl.
Oh, no. Oh, no.
As well they should have.
Oh, no.
I mean, talk about clogging up the courts with needless litigation. I mean, that would just be.
We don't want that. We don't want that.
You can call your legislator and get them. When you call the legislature, and get call your senator, make some law about it. But as it is right now, no.
That's it. Okay. Well, we're not going to accept that. But listen, on that note, we are going to say good night, gentlemen. Thank you so much for being with us. I'm Morgan Dukes, Carl Reynolds, BJ Savannah. Until next time, thank you for watching LawCall. Good night, everybody.
Good night, Morgan. Good night.